Good afternoon. I think it's still afternoon. Thank you all for coming along this afternoon or this evening, whatever it is. My name's Paul Tutty. I'm one of the principals here at Aitken Partners. I practice in litigation, insolvency, and occasionally in owners' corp matters, but these days I quite like to leave those matters to Deb. I'm sure most of you know Deb. When it comes to all things OC, she's definitely our go-to person. We're very pleased to welcome you this evening for something that's a little bit different to the usual seminars that we would usually do. So I'm hoping that you'll all take something away from this. A couple of housekeeping things before we start. If anyone needs the bathrooms, they're just by the lifts. After the seminar, we'll do, what are we calling it? A mock hearing or something like that. We'll have questions, answers, the rest of it. And then at about 6 o'clock or so, we'll have some food arriving. So please don't rush off after we're finished. Please feel free to hang about, mingle, have something to eat, have a few drinks. We'll all be around and celebrate what is the last Owners Corporation seminar we'll be doing for this year. So without further ado, I'll hand over to Deb.
Thank you, Paolo. Yeah, thank you all for coming. As I was saying out there, I thought that this might just be a fun way to close out the year, and it'll give you a bit of an insight as to what happens in the VCAT room when we do go after recalcitrant lot owners. No doubt you will find it entertaining and informative, so no pressure, guys. So I will be narrating as we go along, just to go through the process, relevant sections of the Act, or just a bit of information as to tips and tricks along the way. But we will have a Q&A at the end, so if you've got any questions, please feel free to yell out. So, so we've got Val and Owen, who are senior associates in our property and litigation teams. Oren will be our Owners Corp solicitor. Father will be our member. Val is going to be our recalcitrant lot owner.
Big shoes to fill for both of us. You can just be a usual lawyer.
Okay, so Section 100, subsection 3 of the VCAT Act provides that the tribunal may proceed to hear and determine the fee recovery proceedings on the papers or in the absence of the parties, despite any objection made by the respondent, if the tribunal is satisfied that the respondent's objection is not reasonable.
Okay. Good afternoon, parties. This is the hearing for Owners Corporation case OC 486 or 2022. Owners Corporation PS 12345B and Peter Kemsley. The matter's been listed in response to the respondent's notification he did not consent to the matter being determined on the papers because he disputes payment of fees. My name is Senior Member Alan, double L, if anyone asks. You may refer to me as Member or Mr. Allen. Mr. Richards, you appear for the applicant Owners Corporation.
Good afternoon, Senior
Member.
You may remain seated. Thank you, Senior Member. Good afternoon, Senior Member. Yes, I appear on behalf of the applicant OC.
And you seek permission to appear today?
I do indeed. I believe I would be of greatest assistance to the tribunal here today.
Mr. Kemsley, do you have any objection? Generally, the tribunal allows a legal practitioner to represent an Owners Corporation, given it does tend to assist.
I mean, if this is going to progress the matter, I'm sure it's fine.
I will allow the representation today. And of course, you are Mr. Kemsley.
I mean, with a K, right?
Of course.
Then I am.
Can I just confirm? Kemsley.
That's right.
Mr. Kemsley. Mr. Kemsley, before we begin, I'll ask you to read the oath or affirmation that's in front of you. Mr. Richards does not need to do the same because he's a solicitor representing the Owners Corporation. It's a matter for you whether you read the oath or the affirmation, depending on whether you're a religious or a non-religious person. And it just means that you will tell the truth and promise to tell the truth in everything you say during this hearing.
I'll take an affirmation.
Thank you.
I solemnly and sincerely declare and affirm that the evidence I shall give will be the truth, the whole truth, and nothing but the truth.
I stole Deb's thunder there by ad-libbing a little bit, but we'll move on. Thank you, Mr. Richards. I can see that you filed a summary of proofs. Mr. Kemsley, have you seen this document?
I'm a very busy person, so no, I have not seen it, but I'm sure it's sitting somewhere in my inbox.
Okay, well, I might just have Mr. Richards walk us through it so that we can both go through it together. And then if you've got any questions, we can deal with that afterwards.
Okay, so the summary of proofs is filed in lieu of the affidavit that we used to file pre-COVID and sets out the evidence that the OC relies on in bringing its claim against the lot owner. The summary must be accompanied by a stat deck signed by the manager or any other person that has access to the OC's records and accounts.
Thank you, Senior Member. Senior Member, the respondent, Mr. Kemsley, is the owner of lot 24 and has instructed the respondent in this matter is the OC manager and has instructed us to issue notices via email to Peter Kemsley at his email address that he has notified us, which is peterkemsley@bigpond.com. The OC has issued the notice to the respondent via email on 12th of April 2022. It itemised all the levies claimed for the quarter commencing 1 January 2020 and the quarter ending 30th September 2022. As you will see, it's been quite some time since Mr. Kemsley has paid his owner corporation's levies.
Well, we'll get to that in a moment.
So, fee notice is issued pursuant to Section 31 of the Owners Corporation Act, and it is very important that the fee notice states that the lot owner has an obligation to pay the fees and charges within 28 days of receiving the note, or the date of the notice rather. It must state that interest at the rate specified in the notice will be payable in respect of any overdue fees and charges, and also include details of the dispute resolution process that applies under the rules in respect of the disputed fees and charges. In addition, the fee notice must be in the approved form and must state that it has been issued in accordance with Section 31 of the Owners Corp Act. If any of that information is missing, VCAT will not make orders because it will deem the fee notice invalid and therefore not served on the lot owner.
Senior Member, I note in addition that the OC has issued a final notice on 16th of August 2022 for the outstanding levies.
Similarly, the final fee notice is issued in accordance with Section 32 of the Owners Corporation Act and is not to be issued unless the money owing pursuant to the earlier fee notice has not been paid within the 28 days of the fee notice. So if you issue a fee notice today and you issue a final fee notice in a week's time, that's not valid. You have to wait the full 28 days before you can issue that final fee notice. Additionally, the fee notice must state that the lot owner has an obligation to pay the overdue fees and charges and interest immediately. The interest is payable in respect of the overdue fees and charges at the date of the final fee notice. The amount of the interest that will accrue daily until the payment of the overdue fees and charges has been paid, and that the Owners Corporation intends to take action under Part 11 to recover the amount due if the overdue fees and charges and interest owing are not paid within 28 days of the final fee notice. The final fee notice must also be in the approved form and state that it has been issued in accordance with Section 32 of the Owners Corp Act. Again, if any of this information is missing or it has been issued less than 28 days before the fee notice, VCAT will not make orders and will deem the final fee notice invalid, and therefore the OC will have to start its application again.
Senior Member, you will observe that the final notice was in the approved form and does include all the information generally required by Section 32. The levies claimed have been struck on Lot 24 in accordance with the lot liability and pursuant to the annual budgets approved at the 2019, 2020 and 2021 annual general meetings.
And I assume you would submit that they have been issued at the appropriate times?
Absolutely.
Thank
I
you.
can take that. Take it, senior member, through that if you'd like me to. But
No, that's all right.
Section 23 of the Owners Corp Act requires that the levies struck on lots are in accordance with their lot liability. However, there is now a new section 23(3)(a), which allows an Owners Corp to levy an additional fee on a lot owner using the benefit principle, provided that the Owners Corp has incurred additional costs arising from the particular use of the lot by the lot owner, and an annual fee set on the basis of the lot liability of the lot owner would not adequately take into account those additional costs.
Senior member, I do note that interest on the overdue amounts has been applied pursuant to the resolutions that have been passed at those meetings I've just referred to, and have authorised the OC to charge interest on arrears.
You? Let's go step by step.
Section 29 of the Owners Corp Act provides that if authorised by a resolution at a general meeting, an Owners Corp may charge interest on overdue arrears in accordance with the Penalty Interest Rates Act of 1983. In the absence of such a resolution, the OC can't charge interest. We recommend that the resolution is passed every year at the AGM so that there can't be any dispute, because lot owners tend to always want to dispute interest if they think that they've got a losing case or if they're trying to strike a deal with the OC. So in order to avoid any doubt, we want to make sure that we can tell VCAT, yes, we passed it at the last AGM.
Senior member, you will observe that the total amount claimed is quite substantial, as the overdue levies and interest is $10,254.75. This is a significant amount for the operation of the OC management. The OC naturally also seeks orders for both its reasonable costs and legal costs incurred in this proceeding.
Okay, so new section 165(1)(ca) of the Owners Corporation Act gives VCAT the power to order a lot owner to pay the Owners Corporation's reasonable costs incurred by the Owners Corporation in recovering the unpaid amount from the lot owner. This is not cost of the proceeding, so it's not the usual $750 order that VCAT makes. This is in addition. So reasonable costs may include the manager's 2.2 charges under the contract of appointment for issuing the final fee notice, or what we commonly call a late fee, and also the OC's legal costs before the application was filed. So it might be the legal costs incurred for issuing a 7 or 14-day letter of demand. And I will discuss a little bit further on that. Look.
So thank you, sir. I've had an opportunity to look at your summary of proofs and confirm that, in my view, the notices were issued pursuant to Section 31 and 32 of the Owners Corporation Act. I also confirm that those fee notices include the details of the dispute resolution processes that apply under the rules in relation to any disputed fees and charges, and otherwise, to my mind, they appear in the prescribed form. The applicant also, on my reading of all of the material, has complied with its obligations and with the application, which has been filed in accordance with Part 11 of the Owners Corporation Act, and is therefore entitled to proceed.
So Section 162 of the Owners Corp Act gives VCAT the power to hear and determine a dispute or any other matter arising within the Owners Corporation Act, the Owners Corporation regulations, or the Owners Corp special rules. The amendment to Section 18 of the Owners Corporation Act came into effect last year and provides that the Owners Corp does not need to pass a special resolution to issue a debt recovery proceeding is less than 100K. However, if you're seeking to recover more than 100K, for example, we've got an OC that's trying to recover just short of 500K worth of unpaid insurance levies, a special resolution will be necessary to proceed before VCAT will hear the matter. I did test this and argued with Member Rowland that it was not the legislature, it should not have been the legislature's intention to make it harder. While she agreed, she had to go with the way the acts have been written, and therefore we had to go back and issue a ballot to get the special res. So luckily we did in that one, but I would recommend that the OC tries to get the special res from the get-go so that the matter can just proceed smoothly. But I wouldn't imagine that there'd be too many that are over 100K.
Now, Mr. Kemsley, I've spoken to the Owners Corporation's lawyer a fair bit, and most of what we've discussed is legal talk, and that's just to confirm that all of the paperwork is in order for the Owners Corporation to proceed. And to my mind, unless there's anything you'd like to tell me about the form of the notices or the paperwork, it does appear that way. I would note that you filed multiple documents outlining a number of grievances against the Owners Corporation and the manager. But it's unclear to me why you say that the levies that are the subject of this proceeding are not due. So if there's anything you'd like to say to the tribunal, now's your time to explain those reasons.
I've actually got a lot of things to say. For starters, my ex-wife was not entitled, but I believe she should be here at the moment. Her name's Doreen Kemsley. I don't know why I'm here. It's a waste of my time.
So just on that point, are you entitled to this property?
Well, yes, I am.
So that's the reason why you're here. The fact that you might have a grievance with your ex-wife is not relevant to this dispute. So what I need to understand is why you say that levies that have been given to you by the Owners Corporation, they've sent you a notice, they've sent you a final fee notice and you haven't paid, why you say you shouldn't pay those.
I'm just not happy with them. I mean, what have they done for me in the last 3 years? I mean, the things that they're asking for and the things that I've been chasing, they're just not good managers. I've been asking for the furniture in the lobby to be changed for the last 6 months. It's old and cheap and it looks tacky. It looks tacky. People have come to me and said, your furniture in the lobby looks tacky. Can you believe that? I'm not paying this sum of money for tacky furniture.
Well, look, I live in an apartment complex and I understand that completely, but one of the things that you need to appreciate is that this is not the time and place for that grievance. All lot owners are obliged to pay fees to the Owners Corporation in accordance with the lot entitlement that they're attributed. Every lot owner needs to pay that to ensure that the Owners Corporation can function and provide services to the building. Your grievances might be legitimate, I don't know, but now's not the time and place for those grievances to be brought before the tribunal. You have other options if you're not happy with the manager and if you're not happy with the Owners Corporation Committee. For example, going onto the committee yourself. But unfortunately, even though your grievances might be well placed, they're not a matter for the tribunal today. You need to pay fees just like every other lot owner needs to pay their fees, and that obligation arises under the Owners Corporation Act. If you're not happy with the manager, you need to go along to a meeting and raise those grievances, get onto the committee, but that's not a matter for today, sir.
You want to talk about services being provided. What about the 1 metre grass that's growing outside?
Again, they might well be valid grievances, but that doesn't mean you don't get to pay your Owners Corporation fees. Every lot owner in your building needs to pay, and that's passed by way of budget and other things that happen at the AGM. If you have these grievances, and they might be legitimate, they need to be raised at the meeting, and you should perhaps consider getting onto the committee. And if you've got a grievance with the manager, I would suggest that you send them an email setting out your issues. And if you're not happy, it might be better to get legal advice about your options.
No. I don't want to be part of the committee. I'm too busy to be part of the committee. And then calling these meetings at really weird hours of the day.
Again, that might well be true, but this is a fee recovery proceeding. The legislation is clear. Every lot owner needs to make a contribution to the Owners Corporation.
Tribunal member, I'd like to be noted on the record that the 24th of December is not an awkward time to host an OC.
Well, so that might be your view, but if that matter came before the tribunal on a different application, I might have a very different view and will restrain you from doing that. So if your client is holding meetings on the 24th of December, perhaps this lot owner should be bringing a different application before the tribunal. Are you inviting that today, sir?
No.
No, so perhaps we'll leave it there. Coming back to you, there are options available to you. There are options, but unfortunately, this is not the forum for that particular grievance to be raised. Every lot owner needs to pay, and when one lot owner doesn't pay, it impacts the entire owners corporation. It impacts on insurances. It impacts on all sorts of things that it's in your interest to be paid. So as much as you might be unhappy, and it might well be the case that that's rightfully so, you need to take the appropriate steps. And not paying your owners corporation fees are not the right step to take.
I've received no direct benefit from the things that they're proposing.
Well, as you'll know, if you look at the budget, I'm sure that the owners corporation is covering things like insurance for the building. There might be lift maintenance. I'm assuming that this is a multi-level dwelling. There are all sorts of benefits that you will receive. But if that's your grievance, that's fine. It's not a matter for today, sir. Okay?
Well, they've caused me significant distress.
Sir, I appreciate that. But unfortunately, I'm going to stop you there, because all of those grievances are not a matter for today. The Owners Corporation has given you the relevant fee notices. They have served you with those fee notices, and in accordance with not only the Act, but the resolutions that the lawyer for the Owners Corporation has shown me, it does appear to me that unless there is any legal reason you shouldn't pay, you will need to pay that amount.
This is total BS. Total BS.
Sir, this is a tribunal. I'll ask you to just restrain yourself. I appreciate that this is a little bit emotional for you and that you do have some grievances. But as I keep saying, we're here to apply the law, and those grievances cannot be dealt with today.
So you're saying I've got no choice but to pay this sum of money?
I'm saying that if there's a legal reason for you not to pay the money, I will hear that. But based on your grievances, they are not appropriate reasons for the tribunal not to grant the orders that the Owners Corporation is seeking today. Is there any legal reason under the Owners Corporation Act?
I told you my grievances.
And I've heard you, and I've explained to you the reason. So unless there's anything more than what you've already told me, I'm going to proceed with the hearing.
That's
So
not my vibe.
this is a tribunal, and we do have contempt powers, so I'll ask people who are sitting in the gallery to please be quiet and wait until their matter is heard. Thank you, sir, or I'll have you removed.
Just put up an excerpt from the orders that are made from VCAT when they list matters to be determined on the paper. But in all our experiences, I think it's safe to say that lot owners generally don't pay their levies because they have an unrelated grievance with the OC or the manager, or they don't understand what they've been asked to pay or why they've been asked to pay, or some other random unrelated reason as to why they haven't paid. Another common response to the proceeding is, well, if the manager picked up the phone and bothered to call me, I would have paid. Whether that's true is another story, but that seems to be one of the excuses as to why they haven't paid. So I've written here, in most instances, in most, not all, telephone conversation with the lot owner before instructions are given to the solicitor to issue proceedings may resolve the matter. That's not necessarily the case. I think it's on a case-by-case basis. It might be part of your business strategy to make that phone call. It might not be. But if it's a lot owner that's maybe defaulted once or twice here and there, it might be worth giving that call. But if it's a lot owner that's constantly late, breaching the rules and doing all those sorts of things, then it's probably going to be a waste of time, and you might as well just go straight to VCAT. But as Bao has demonstrated, there's the sorts of reasons why people generally don't pay, and the sorts of grievances that we hear when we are in the tribunal and not on the papers.
Now, sir, can you please remind me of the amount of the claim and confirm whether or not that includes interest?
Yes, senior member. That amount was $10,254.75, and yes, the manager is telling me that that does include interest owing on the final fee notice.
Thank you. And what interest do you claim from the date of the final fee notice to today's hearing?
Interest from the 16th of August, the date of the final fee notice, to today in the sum of $345 $2,058.20.
Thank you. And are you claiming reasonable cost for today?
Absolutely.
And can you tell me what they are?
We claim the sum of $440 for reasonable costs, which comprised $330, which is a bargain these days for a letter of demand,
I'll ask you to stop with the commentary, sir. It's not.
issued to the respondent by my firm before this proceeding was filed, and a further fee of $110 for the manager's time to review the lot account and issue the final fee notice.
And do you have proof that those costs were in fact incurred by the Owners Corporation?
Yes, the OC has received an invoice from my firm for the letter of demand. I believe it may have made its way to the file.
Yes.
And the manager's fee has been incurred pursuant to Schedule 2.2 of the manager's contract of appointment, dated 15th of April 2020. And once again, this is, I believe, included in the summary proof.
Yes, I've got that. As you'll be aware, the Tribunal's got a discretion when it comes to these costs and it can exercise them however it deems proper. I've looked at the material and I'm only going to allow a sum of $200 for those costs, in part because you were trying to be smart.
Will the senior member hear me
The senior member will not. I'm going to allow $200 for costs.
as the tribunal, please?
Thank you, sir.
So, reasonable costs. There was the test case of Owners Corporation and Singh, where the tribunal chose 3 proceedings as the test case, as examples of the types of claims for costs incurred in recovering unpaid owners' court fees from lot owners, other than costs in the proceeding. The reasonable costs awarded in the 3 cases were not the same, and as such, there's no clarity as to how much VCAT will award. So we don't have a set fee, such as the legal cost rate might be $550 for claims under 3K, $750 for claims over 3K. We don't have a set figure. Every order that I've received in the last couple of months has been different as well. We recommend including in the summary of proofs the solicitor's invoice for the letter of demand, and also a copy of the manager's contract of appointment to recover any of your 2.2 charges. So way back when we used to include the manager's contract of appointment in the affidavit, we then took that out because it was a lot of paperwork, and it seems that it's now back in. We're not currently including minutes of meetings, but that's yet to be seen. However, one thing that I did take away from the Singh case is that if you're issuing multiple final fee notices before you get to VCAT, you might wait 3 or 4 quarters to let the amount of the claim bank up. VCAT's not going to give you 3 or 4 2.2 charges, they'll only give you 1. If you're issuing against multiple lots owned by the lot owner in the 1OC, you may get a discounted amount for the one fee notice for the multiple lots. But again, it's currently on a case-by-case basis, yet to see if VCAT's going to come up with a schedule as to what they deem reasonable and what they deem as overkill. So watch this space.
Now, before I go back to the lot owner, sir, I assume you also seek legal costs of today?
Yes, senior member. Given the quantum, we seek legal costs in the sum of $750, and I will say that this includes the filing fee of $321.10.
Thank you. Now, so the discussion I've just had with the solicitor is in relation to costs. As you've heard, the Owners Corporation is entitled to certain costs. Having had to bring this today, I've knocked back the request that's been made for the full cost because I didn't consider that to be reasonable. However, proceedings did have to be issued for the Owners Corporation to recover these fees from you, and the amount that's now being sought for those legal costs, being $750, including the filing fee, is in my view very reasonable and generally what the tribunal would order. Do you have anything to say about that?
That's not reasonable. $750 to do what?
Now, obviously an application had to be made to the tribunal, a summary of proofs, which you've seen today, setting out the basis, the fee notice, the final fee notice, the interest calculation, all of the ancillary documents, and of course the time for being here today. In my view, it is reasonable and it is generally what the tribunal grants in these cases.
What about my time for being here? I mean, the amount of time that I had to call the manager and receive no calls back, I don't get why I have to pay this $750.
Well, had you paid, at the time the fee notices were issued, you wouldn't be in this position. You chose not to pay them. And as I said before, you might well have some valid grievances against the owners corporation, but this isn't the forum for that. As a lot owner, you, just like everyone else, needs to pay your fees. Now, the owners corporation has been put to the trouble of coming here to seek those. It is not fair for other lot owners to receive or to pay their money on time and have the full benefit of that money applied to the owners corporation. The fact that costs have been incurred, they should recover those so that the full amount of what you owe is made available to the benefit of the owners corporation.
But I've
Do you
spoken to my
understand,
friend.
sir?
I've spoken to my friend.
I don't care what you've spoken to your friend about, sir.
They don't want to charge me
Sir,
$750.
The tribunal generally grants these orders, and unless there's a very good reason for me not to, I'm going to make that order.
Well, you can make the order. I'm
Right. Well, I'm going to allow $750 in legal costs.
Starting position at VCAT is that all parties bear their own costs. However, it's common practice in the owners corporation list that costs will be awarded in debt recovery cases, as VCAT has taken the view that it is reasonable for the owners corporation to engage a solicitor in debt recovery matters, and it is fair to require the recalcitrant lot owner to pay a higher portion of the legal costs compared to all the other lot owners. So VCAT relies on the power in Section 109 of the VCAT Act to use its discretion to make those cost orders. We generally tell the owners corporations to leave the full amount on the lot owner's account, and if it's then challenged, then you would have to remove the extra amount compared to what was ordered by VCAT. And so it might be $200 or $300 more, and then that amount would have to be issued on all lot owners in accordance with lot liability.
Right. So we've come to the part of the hearing where I'll proceed to make orders. I've now heard from both of you. I've made some decisions, so I'd be grateful if you didn't interrupt me so I could get through this. Having examined the summary of proofs before me, I find the respondent is the lot owner of lot 24. The applicant has served upon the respondent a fee notice on 12 April 2022 and a final fee notice on 16 August 2022. The fee notice and final fee notice were in the appropriate form. The application before the tribunal contains all the relevant material. I'm satisfied on the summary of proofs that I should make the following orders. I'll order number one, the respondent pay the applicant the sum of $10,254.75 for overdue levies and interest. 2, the respondent pay the applicant $345.20 for interest from the final fee notice dated 12 August 2022 to today's date. 3, the respondent pay the applicant the sum of $200 for the applicant's reasonable costs in bringing these proceedings. And 4, the respondent pay the applicant the sum of $750 for the applicant's legal costs. That brings the total amount to $11,549.95. Sir, do you agree with that amount?
Just need to recalculate. I was expecting some higher reasonable costs, but yes,
I
I
made
do.
my decision on that, sir. Thank you.
I understand.
Do you have any
Member.
issue with the calculation that I've...
I'm not paying. I told you this.
Well, that's fine. It is an order of the tribunal, so it is expected that you'll comply with the same. If you do not, and you do not want to comply, I suggest you get some legal advice. The owners corporation has certain enforcement powers available to it, including taking action in registering it in the magistrate's court, and ultimately they may in fact be able to sell your property. So if you're not going to comply with an order of the tribunal, I seriously suggest that you go and get some legal advice. Because a breach of the order is quite a serious matter. Otherwise, is there anything else from the owners corporation side, sir?
No, I don't believe you, senior member. Thank you very much for your time.
Thank you for coming today. I appreciate you have some grievances, but the law requires me to make certain orders. I've made those orders. The parties will receive a copy of those by email in the next few weeks. As I say, sir, I'll just reiterate, it is a very serious thing if you do not comply with an order of this tribunal. I suggest you go and get some legal advice. I'll otherwise adjourn the hearing, and thank you. You may both leave.
So as the member mentioned to the lot owner,
Senior member.
senior member,
I got
Apologies.
promoted during the hearing.
once an order has been made by VCAT, in order to take further steps for enforcement, it's got to be registered in the magistrate's court, and that's a sample of what the orders look like now. So we can either go down the path of garnishing rental wages, we can go down the path of issuing a warrant to seize property, and then if there is no property that can be seized, we can uplift to the Supreme Court to sell the actual lot via public auction. We can issue a bankruptcy notice, or if it's a company lot owner, we can take steps to wind up the company. So it all depends on the amount of the order and the OC's preference as well, but we always assess it on a case-by-case basis, and what we do for one lot owner doesn't necessarily mean it's what we'll do for their next door neighbour in the same OC. So thank you for watching our presentation, and we'd be happy to take any questions.
So to be on the safe side, when it comes to our living notices, should we send them to you to read to see whether or not they do comply? Because if we're ever in that situation where it happens period after period, what happens then if you notice that the levy notice itself doesn't comply with the response?
So if your levy notice doesn't comply, you'd have to issue brand new levy notice. You can itemise everything because VCAT doesn't take too kindly to balance brought forward in fee notices unless you go back and provide every single one. If you've got any doubt as to the validity of your fee notice and final fee, we're happy to have a look. But a lot of the programs that the Owners Corps use will generally create the notice, and it should have everything on there. But if you're creating your own, that might be when it might be worth having us just cast our eyes over it.
Although, can I say, I have had experience, I'm sure you have as well, where some of these off-the-shelf programs that managers have been using, the notices aren't compliant. And the most common issue is actually just the notice that needs to be provided on the back, which is in the regs.
Yeah.
It should just be a matter of copy and paste. But the number of times I've actually seen a program spit out the notice wrong is incredible. In particular, the interest. For some bizarre reason, a number of the programs I've seen get the interest statement wrong. And there's one other one that's quite often wrong. It's towards the bottom part that appears in bold. Anyway, the wording gives the same message. The wording gives the same message, but there's a couple of critical words missing. And I've seen, luckily it hasn't been in any of the cases I've done, but I've been in the tribunal before where the tribunal members picked up on that and said, notice is invalid.
Yeah, and just making sure that that dispute resolution notice is included because it doesn't seem like a big deal and it should not affect whether or not the levies were valid struck. But if you get a lot owner that picks up on that technicality
Or a member.
or a member, your matter's going to get struck out. And all it takes is just that one to then set off all the other lot owners. I had one probably about 6 or 7 years ago where the program always spits out that second notice. There was a glitch in the system that day. We got our case thrown out of VCAT, and he created a Facebook page to alert all his fellow lot owners. So we had to end up withdrawing everything, even debt recovery letters, because we thought, okay, well, it's just not going to be worth the fight. Just reissue and do it all properly.
And a number of you will have done your own fee recovery hearings without lawyers, I assume, and you'll have seen the difference in members. I mean, there are some members that will just go through the motions. There are others that will entertain, stories like that for a little bit, and they'll give them a bit of rope, and then they won't. There are others that will just cut them off at the heels and say, no, not listening. And there are others that will literally scour through every word of the proofs that you filed, every word of the notice you filed, and they'll look for any reason to knock it back. So it really does depend on who you get. And that's why something like your fee notices and your final fee notices, because you use them so often, get them right. Just make sure, and as I say, in particular, that notice on the back, it's in the regs. It's a copy and paste. If you are using an off-the-shelf program, go to the regs and double check that it's actually word for word what's in there. Sorry.
Yeah, and to your point, a lot of these software providers are national companies that don't always differentiate the templates by state.
Yeah.
We've all been caught on that. But for the dispute resolution on the fee notice and final fee notice, or final fee notice, not so much.
Not so much on the final fee notice. There's some managers that provide it in both to cover all bases. The Act requires it to be in the fee notice. The main thing about the final fee notice is the interest component. So if it says 10% but doesn't provide a daily figure, some members won't even allow interest just based on that. So it's just making sure that all those little technicalities have been complied with on your notice. But if you're wanting to overkill and have it included in both, then there's no reason why not. That's not necessary.
And again, to support what you said, if there's anything technicality wrong in any of your notices, they get wrong, not the provider.
Yeah.
Make it look incompetent.
Yeah.
Get the cost to that.
Is there any penalization for reoffenders? Let's say the lot owner pays this time. The next year, we're back at it again with the same lot owner, same story, year after year. Is there any penalization for it or any disencouragement, or it's just a process you have to?
No, it's just a process you have to go through. So unfortunately, we can, when we're making submissions to the tribunal, say, well, we've done this 3 other times in the last 12 months with this lot owner, but they treat it on a case-by-case basis. It might just make a more compelling case to have costs awarded, if anything. I've also had instances where the OC has been a little bit slow in taking action, but we've had 3 different proceedings on foot all at the same time because the final fee notices have covered 3 different periods. And again, they might all be heard together, but VCAT will still treat them on an individual basis.
Let's say the lot owner doesn't pay and it goes to a bankruptcy proceeding or something of that sort. What's the standing or the pari passu standing against other people that, let's say the bank is recovering the house, who gets preference? And if you have to wait 28 days from one to the other, in a bankruptcy hearing, the timing would be critical. Is there any exception you can make? Like, I made my first notice 28 days ago. Like, how does it work time-wise or preference-wise in a bankruptcy proceeding?
So the debt runs with the land. You can make the lot owner bankrupt if the mortgagee has issued proceedings. In most cases, it's usually not a large OC. So we normally advise them not to issue any proceedings and just let the bank's process take its course, because you will get paid at settlement because the debt runs with the land, not with the individual.
You're running 2 separate issues there. I do a lot of bankruptcy and insolvency stuff. Even though an owner's corporation might bankrupt someone, you don't need to worry about your standing or pari passu with other creditors and the like, because you'll never get to a point where you're going to have to put in a proof of debt with the trustee in bankruptcy. As long as the property is sold, and whether that's by the trustee in bankruptcy or the mortgagee, the owner's corp fees are going to get paid because, as Deb said, it runs with the land. So no purchaser is going to buy the property without a certificate from you guys saying this is how much is owed and that amount being adjusted at settlement out of the proceeds. So the only time it would ever conceivably become an issue is if the mortgage is higher than what the value of the property is. Now, if that happens, even then, you would arguably still have rights against the new owner of the property. So you never really end up in that situation, because under the Act, it just runs with the land. It's like it's almost a statutory charge, if you like. So it's like, rates. It has the same standing as those things. And in my experience, banks will treat owner's corp fees as though they were rates, as though they were any of those other commonly found things on a statement of adjustments, where if it means they don't get paid their full amount, they'll still be adjusted, because no person in their right mind, so there are people that will do it, they're just, not in their right mind, or they haven't sought advice, is going to buy a property where they haven't got clearance from rates, council, water rates, OC, and know that they're taking it on day one with zero liability. So technically it's possible, hypothetically it's possible. It's very unlikely, very, very unlikely it would ever happen.
Yeah, from the owner's point of view, can the penalty interest be challenged because it doesn't reflect current market values? And for years, it's been very low. The interest
So,
is it defined in the act?
so the penalty interest rate is determined by the Attorney General. And so whatever that is pursuant to the Penalty Interest Rates Act is what the OC can charge. You can't charge more. I've never seen an OC charge less. They usually either resolve to charge penalty interest in accordance with the Act or not to charge interest. But yeah, it looks like it's been set to 10% for the next 10 years or so. Yeah, 20, 40 years.
And the other thing that's important to remember is that there's two levels of interest. There's the interest that's under the fee notices and under the OC Act. And so if you don't have your resolution, you're not getting that interest and the tribunal won't order it. But once the tribunal's made an order, it automatically attracts statutory interest from that day until it's paid. So there's two levels of interest here. So even though if you haven't got your resolution in place or the tribunal finds some technical reason not to permit interest between the date of the final fee notice and the hearing, the second the tribunal makes an order, that interest rate kicks in. So until it's paid, interest will start accruing at that penalty interest rate.
Yeah, if we issue a warrant to seize property, we will calculate interest from the date of the registered order to the date of the warrant that we file. The courts used to do it all through snail mail, so there'd be 4 weeks in between. So you'd be able to claim 4 weeks worth of interest.
Now it's just 4 weeks until registry give you the order.
Yes, and then
By
the date of the order
Edit that
compared to the date that we receive it is maybe only 2 or 3 days, so you're only getting a couple of dollars worth of interest, but we still put it in.
So that is got 2 levels of interest.
No. So the interest under the fee notices is only until the date of the order, and for practical purposes, it's the same percentage. So it doesn't matter. It's only if the fee notice doesn't have the appropriate wording on it for interest, or the owner's corporation hasn't passed the resolution, that you might lose the interest pre-order, but you're going to get interest post-order. Or a lot owner is going to be obliged to pay that post-order until they pay.
Costs and expenses, could you also go for damages? If you were fined along the way, if there wasn't enough money to pay the insurance, something happened and you got a fine, or the fire extinguishers were not fined, whatever, you get fined for it. Could you go for damages against the lot owner? Because you didn't comply with your obligations in time and you were fined?
In the case that's had to do that, I suppose if we can make out the claim, we can certainly put it in our application, then it's a matter for the tribunal.
You need a special res though, to
Well, it depends
to
on,
claim.
no, if it's under 100K, we can,
Damages claim though.
yeah. It may not even be.
The issue there, it's a complicated issue that it would depend on all of the circumstances, but just because the OC doesn't have money to pay doesn't mean it doesn't have the obligations it has under the legislation. So, for example, like we've dealt with a fairly large owner's corporation, 2 towers in the city where, 60% of lot owners haven't been paying, and so there's been huge issues, litigation, all sorts of reasons they haven't. And so special levies needed to be raised to, try and get some money coming in quickly to be able to pay these things. I think if that circumstance arises where the owner's corporation wasn't in a position to maintain, an essential service, things like that, definitely get advice ASAP as to your options, because I don't think it's going to be good enough to point the finger at 10 lot owners who haven't made the payment. There's obligations, duty of care, all of those things, both on the owner's corporation, but also the managers. You shouldn't forget that as a manager, you're sort of the custodian of the owner's corp, you're engaged under a contract to perform particular services. It's not to say that you're obliged to put your hand in your pocket and do these things, but there are obligations to take certain steps. And if it's a case where, you can't get the fire extinguishers up to code, there are real problems. There's real exposure at all levels. And you should be thinking about things like an administrator, things like that. Someone to come in and fix the problem. Conceivably, could you sue someone? I have some doubts. I think it's possible. And Deb will tell you I'm pretty creative when it comes to suing people for things like that. But, you can't say that lot owner's money was going to go to paying that service. And so it's a causation issue. If you're not paying and there's 100 owners and, that was the 10 grand you needed to service the.
But let's say the case of the 500,000. We're talking about big amounts. If you tell all the other loans, we have to do a special levy to cover for this guy that's not paying, they would probably say, no, that's his problem.
But again, their rights are to go to the tribunal and complain about those levies. It's the same exchange we were having before. That's not the question for today. If the owners corporation, if the committee agrees to make that levy, then until the tribunal comes in and says, no, that levy is improper, that's a proper levy. So again, it's an issue for committees and it's an issue for managers who are advising committees. I suggest you get advice very early on in those cases, but quite often one of the things that's overlooked is the appointment of an administrator. And it doesn't have to be a liquidator. Like it can be an accountant, it can be an independent person, but sometimes you need that sort of person to come in and break the divide that's existing. But I don't think you should assume that because, 50% of lot owners aren't paying, that they're going to be responsible if something goes wrong.
I had a situation where we had one in a garden where we were going to take some works because it was old, people were falling over, tripping over. We tried a similar argument of because these two lot owners haven't paid, we haven't been able to do the works. The tribunal didn't get it, didn't buy it.
Yeah. And you do have to be really careful. I mean, I'm trying to remember exactly the circumstances, but, on occasion I've sued an OC on behalf of a client, for something that's a bit creative in terms of breaches of duties and things like that. And as much as we all have that experience of there's, 170 members of the tribunal, probably 50 of them sit in OC from time to time, put the same case before 50 members get 50 different outcomes. When someone gets a bit creative against an OC, they do tend to try and protect the owner's corporation and the manager unless there is clearly something wrong. And that's for good reason. I mean, people make up all sorts of crap. And you guys, the managers in the room, you guys will hear that every day of the week. Someone hates you because you didn't cut the grass this week and you should have. There's a chipped wall somewhere. They'll find something ridiculous to run.
Took me 9 calls in 20 minutes before I finally got a response from the manager.
I called this person 10 times and they never responded. And when did you make those calls? All within 30 minutes of each other. Like, duh, of course they're not going to respond, they're busy. So the tribunal will try and protect where it needs to against those spurious sort of claims, but it's a double-edged sword.
Question to you. What if we cannot trace the lot owner? We're in a situation we can't trace the owners to serve the legal documents.
I would recommend getting a private investigator to do a skip trace. If they're not living in the property, then we would see if there's someone that is living in there that can provide us with some information. Otherwise, get a PI and see what they can find because they've got access to all sorts of databases.
And it's relatively inexpensive these days just to do the base level skip trace. Generally, it's very hard not to find someone. You might just need to put a bit of effort into it.
Next one. What is the limit for bankruptcy?
Is that 10? They put it up during the
Yeah, they put it up, they put it down, they put it up, they put it down. I'm pretty sure it's 10,000 at the moment. I'm pretty sure it's back at 10,000. It did go up to 20 during COVID and then a little bit higher. Pretty sure we're back at 10. But usually for an owners corporation, can I say, I mean, in 15, 16 years, it's probably only been once, maybe twice that I've even gone to bankruptcy. There's generally a better way to recover. And that's because they own the property.
Yeah, I agree. Bankruptcy is an option, but we know they own the lot. That's obviously why we've issued a proceeding against them. So let's get the sheriff involved and see if we can apply some pressure on them to pay up before their property gets sold.
But is warrant of seizure and sale versus bankruptcy, which one's a quicker process?
Or it really
Neither of them are quick.
Neither of them. So, you know,
Neither of them are quick.
because with the warrant of seizure and sale, you've got to issue that warrant before you can get the warrant of sale. However, with the bankruptcy, you've got to issue a bankruptcy notice before you issue the creditor's petition, and so they can both take up to 12 months or longer.
So remember
During
with the-
COVID, I would have told you that go the bankruptcy route,
yeah,
but the sheriff is now back on track.
they're back on track. Yeah,
So with a bankruptcy notice, you serve 28 days. You then got to issue creditor's petition. By the time you serve that, court generally sets its first date 6 weeks from filing. You know, give or take. They're going to get at least a 4-week free pass, if not a 6-week adjournment. And then all it takes is, you know, oh, I want to pay. I'm trying to refinance. Here's, you know, a letter from someone saying they might give me the money, or here's a letter that I sent the bank, and you'll get another 4 weeks. You know, so bankruptcy is generally pretty quick. The registrars in the federal court are pretty good. If they smell a rat, they're not going to give that third adjournment, but you'll generally get the first 2 without, you know, too much work if you do it properly. And the trouble with that is by the time then you get to the trustee being appointed, trustee has to do its investigations. The bankrupt's going to be non-compliant. The trustee's going to have to issue a proceeding. I mean, I've got one at the moment where the bankrupt just refused to comply. 12 months into it, I issued a proceeding, and it's taken me 5 or 6 months, where on Monday we'll get a warrant of possession to be able to go in. So again, in terms of timing, whether it's the trustee or whether it's a sheriff, it's sort of much of a muchness, but I can tell you the trustee is more expensive. But you'll still get paid because it runs with the land. So it's just a timing issue.
Have you seen a case where the member is in favour of something being reasonable outside of the technicalities of the documents for resolution?
Where there's been a deficiency in the fee notice, for example, and nevertheless it's gone through.
Yeah, when that's gone through.
Yeah.
Yeah.
Rare, but it's all right.
But I'm trying to think if there was anything that we do aware of.
If they're alive to it, it's less likely, but there is occasion where
yeah. I mean, I've had final fee notices that don't list the daily rate. They'll just say it's 10%, and some members might let that slide. But I think during COVID, and because it's now all on the papers and they've got the ability to sit there and scan through the documents, they're picking up on things that we probably would have been able to get through pre-COVID. But I suppose it depends on the member. But I do find, especially because of COVID and a lot of the financial difficulties that a lot of people have gone through, VCAT's looking at those technicalities to make sure that we're doing everything right before we go and force someone to pay money that they owe you anyway. But they find a way to maybe buy them a couple of extra months, I guess.
On that interest, the daily rate, I mean, I've seen members previously just say, well, I'm not going to allow you interest on that basis, but we'll let you get an order for the fees. I mean, I have to say, I disagree with the approach the tribunal takes to that, because there's an act called the Acts Interpretation Act, which is sort of a governing piece of how you read legislation. And there's a provision in there that says, as long as, if there's a prescribed form, as long as what's provided is in substantial compliance, it's wording to that effect with the prescribed form, it's allowable. Now, I think the difference between 10% penalty interest and a daily rate to the average person who's reading it makes absolutely no difference. But the problem is no one's going to take VCAT to the Supreme Court to get that question determined, because why would you? It's stupid. It's only interesting to idiots like me as a lawyer. If you had, you know, $100,000 owing, or, you know, probably more actually, because at 10%, you know, it's 10 grand. It's unlikely anybody will ever bring that point to a higher court. But as I said, I think there's an argument, I've run it before. I think they're wrong, but that's the way they approach it.
I've only been in this industry for 2 years. Here, so it's been great today. So I was just wondering, from our perspective as an OC manager, as long as your documentation is all, as you said, schmick, then it sounds like in every case, per se, it would be in favour of it.
And that, if there's any takeaway for you guys, it's get your documents in order. It's the same thing with us, like make sure your resolution reinterest is done, your budgets are passed, when they need to be passed, your fee notices are in the right form.
Don't have your meetings in late December.
Right. Don't have your meeting in late December. As long as you sort of follow those things, you generally can't go wrong.
Yeah, that's right.
I do like to ask Member Basti a question.
So here,
Why is it that VCAT being a tribunal and based on legal representation or legislation, why is it that if you present your case to 50 different members, you're going to get 50? So why?
the same thing is true of courts though, okay? So, for example, in criminal law, put the same set of facts, someone assaults someone, pleads guilty before a magistrate. Put that same set of facts before 10 different magistrates. Some magistrates might give a $500 fine. Some might be minded to give a good behaviour bond for 2 years. Others might give a $1,000 fine. Others might say, no, you know what, I'm going to give you 50 hours of community service. Nothing is to say that any of those decisions are wrong at law, because everyone accepts intelligent minds can differ. It's just the reality of it. Everybody is different. Everybody has their own views, biases, prejudices, all of those things. And there's nothing you can do about it.
No black and white down the line, a penalty for someone who doesn't want to pay it.
Right. And it's like, you ask for $440 saying that that's a reasonable fee. And I said, no, I'll give you $200. Now, if Deb was sitting there, she might say, I'm a bit more sympathetic to OCs. I'll give them $400. I'll give them $450. Val sitting there might take the middle road and say, I'll give them $350. There's no criteria. There's no right or wrong. All of those decisions are open.
That's where you go to court. It should be a right.
But you're getting the outcome. It's just that's within that discretion. And that's because, as Deb said, there's no nothing that I've heard, and I don't think you have either, that they're going to produce a schedule. So most courts have like a schedule of costs that would generally be applicable, subject to discretion. VCAT doesn't have that. And with all due respect to the tribunal, that test case that they've done with the 3 members, I think that's probably caused more confusion than it has actually resolved anything. Because when you read the case, it doesn't actually set down a guideline even, which is what it was intended to do.
Yeah, all 3 cases.
All due respect to them, because they were 3 experienced members.
Yeah.
But I think as lawyers, it's just given us more ammunition to argue.
I should also add, they've got a scale, not scale, for the legal costs. So as I was saying earlier, they might award $550 for claims under $3K and $750 for claims over $3K. But again, it's up to the member's discretion. So if you've got a lot owner that comes in with the sob story, you might only get your filing feedback, you might get nothing. So again, on a case-by-case basis, depending on the member, how sympathetic they're feeling, is the respondent likeable?
It's a complete discretion. And again, so long as it's exercised within, well, it's frustrating for us as lawyers because, and in the world of OC, it's a bit more clear cut because you're arguing about money. Let's be honest, when we're doing fair recovery, it's about money. There are other cases you do about breach notices and all of that. It's just as frustrating there because, again, it's a discretion. But there are certain parameters in which that discretion needs to be exercised. That's why we have a job, I guess, because you have to have that argument with the member and try and persuade them that even though the decision they need to make needs to be between here and here, they should make that decision at whatever end of that spectrum we want them to. And that's our job. As I say, none of the decisions, even though you might get different outcomes, it's not to say that any of those decisions are actually wrong. And in fact, if you appealed them all to the Supreme Court, which you'd never do, but if you did, each of them might be upheld because they were within discretion.
There's a demand. Previously, there was an appetite to issue one letter of demand per lot. If there's a lot owner that owns 10 lots. Now, under that new sort of guidance, saying better off issuing one as a combined one. And then your view on the necessity of having to issue a letter of demand prior to instigating legal proceedings, notwithstanding that's not mentioned anywhere within the OC Act.
Yeah,
Big attitude towards that.
yeah. I mean, I've always issued one demand letter for multiple lots where it's the same lot owner. VCAT recognises that the OCs do take on that extra step, even though it's not required under the Owners Corp Act, but they recognise that maybe 6 out of 10 will pay once they get that demand letter. And that's why I believe that that's why they've allowed it as part of the reasonable costs, because the OCs are taking all these extra steps that they don't have to take, but to try and not get to VCAT, and then they're lumped with a bill because the lot owners still force them to go down that path. But it's there's some OCs that have never issued demand letters and they'll go straight to VCAT. There's others that will do it on a case-by-case basis. But I find that, as I said, about 6 out of 10 will pay or will at least make contact. So it's still a useful tool, but it's up to the OC if they're wanting to take the risk of incurring that cost, because there's no guarantee that they'll get it all back at VCAT.
And it does help with the discretion when it comes to costs. So when you're asking the member to give interest, they should just give it to you if you've complied with it. But when you're asking for the OC costs plus the legal costs, having taken that step, when you can actually point out and say, they got the fee notice, they got the final fee notice, they probably got a letter from the manager or an email or a call or something, then they got a lawyer's letter, you've got 3 to 4, maybe 5 opportunities for them to say something. And if they then run something at the hearing, you can say, well, they could have said this 6 months ago and we would have explained this to them. And for example, the common arguments you hear, my grass hasn't been cut, the furniture's tacky and all of that sort of stuff. If they tell you that at that first stage and you send them an email back or you have a call with them that you can say, I told them this was irrelevant, the member's far more likely to be generous when it comes to those costs. Whereas if they turn around and say, well, I just got these 2 notices and then I've been brought to VCAT, the member's less likely to be sympathetic, I think, in my experience, and give you the higher end of, your costs as an OC and legal costs if there's a lawyer representing them.
I've got 2 very similar questions. Can VCAT decide on payment plans, or do they make an order for the entire payment?
No, so VCAT doesn't have any jurisdiction with regards to payment plans. That's normally something that's decided by the Owners Corp. And there's one of 2 ways that we can do it. We can either agree on a payment plan and then ask VCAT to either make an order striking out the matter with the right of reinstatement, or to make we'll enter into consent orders and they'll make that order. Or we can say to the lot owner, well, the OC has to preserve its position, so we will get the orders, but we will enter into a payment plan after the fact.
What would be the consequence of restricting the use of common property to a lot owner in arrears? What kind of trouble could we get into?
Yeah, the OC can't do that.
What would happen if I was a really responsible OC and I just forbid them the use of the pool or the gym or the electric gate?
So if the lot owner takes you to VCAT to have their access reinstated, it's very likely that the OC would be faced with an adverse cost order for doing that. There's no fine or anything like that, but you're going to have a very unhappy VCAT member. So the Owners Corporation common property is to be used and accessed by all lot owners or tenants that step in the shoes of the lot owner, and there's nothing in the Act that allows you to block their access unless it's blocked for the whole building for some health and safety reason or security purpose. So up to the OC if they want to take that risk, but if the other side lawyers up, then you're going to get an adverse cost order.
Do a case where an OC blocked access to like pool and gym for all non-paying. Was that with you, or did I do that?
You might have done that, but I've just given advice to an OC that's tried to do that as well and told them no.
Because if they bring it to VCAT, I mean, they don't have the winning side of the stick, no?
No, it's a different question.
It's a different question.
Totally
Different question.
different issue.
You can't answer their request of saying you haven't paid. It has to be
No,
something-
because you've got no right to lock them out.
Yeah,
just
you don't
because
get
they
to
haven't
penalise
paid.
them.
Remember that common property is owned by
By
all the lot
lot
owners. The
owners.
OC only holds it as custodian, if you like. So every lot owner in that lot has a legal interest in that part of the property. It's just too difficult to have, in a 100 lot subdiv, have 100 people on that title, and every time someone leaves, comes and goes, somebody else goes on. So they just decided, let's make the OC the owner. But they own it, it's their property. So you're effectively excluding them from their own property.
As a tactic, some OCs have locked a fob to try and force the lot owner to engage in a conversation.
Not functional.
But but
Your words, not ours.
yeah, but it's frowned upon, but it might be a way to spark the conversation. So
I will tell you, it's almost an inevitable way, though, that if an application came before the tribunal for like the appointment of an administrator or something like that, and whether that's because the OC itself was dysfunctional or because the managers weren't looking after it, if there's a pattern of action like that, you're almost guaranteeing that an application like that would succeed.
yeah.
Hi Deborah, I've had a situation where I've had an owner that wants to go into the motor room. And what I did there was, yes, access will be available. You will have to pay them the cost of the company accompany you. But we also need to know why you need to go into that motor room. And we never got a reply from it. What I did is I cost on to him, and I want to know the reason why. He just wanted exercise his right as an owners corporation owner. I can understand later. He brought it up at an AGM, but people try anything.
I think most OC rules would cover that you can't enter the room or you can't tamper with the equipment in the room. If he's wanting to go into the motor room of a lift, I think the OC is well within its rights to say, yes, you can, but you need to have the right, rightfully qualified person there. And the OC could rightfully charge that fee back to the owner. It's an interesting one though, just because he's an owner, he wants to go in, but
I have a weird one. Let's say another one. The parking lot, you want to install electric chargers for your car. It is in the common property. Can you charge it to the OC? It's not technically private property. It's in the common property in the plan of subdivision. Could you charge it under the cost of the OC?
Well, the fact that you're proposing to use common property is an issue because you would need a special resolution to be able to use that, and no doubt one of the conditions would be that any costs incurred would be paid by the licensee. So the OC might receive the bill, and then when they look at the bill, they'll see that this portion is attributable to your EV dock, and they'll charge it back to you. Or they might require that you put in the proper equipment to be able to be billed directly